live. We're going live in 5, 4, 3, 2, 1. We're live.
Foreman, would you open court, please?
Part 1 of the Chancery Court of Davidson County will now transact the business for which it was created. All persons.
You're now live, Chancellor Moskal.
I'm sorry. Could you repeat that, please?
All persons having business before this court, draw near, give attention, and you shall be heard. God save the United States, the state of Tennessee, and this honorable court. Circuit Court Judge Mary L. Wagner, Chancellor Jerri S. Bryant, and Chancellor Patricia Moskal presiding.
Thank you. Good morning to all. I hope everyone is connected well and can hear us. Welcome to the Davidson County Chancery Court Part 1. We are before a 3-judge panel assigned by the Tennessee Supreme Court to hear and decide this case. I'm Chancellor Pat Moskal. Joining the 3-judge panel are Chancellor Jerri Bryant, 10th Judicial District for the Eastern Division of Tennessee, and Circuit Court Judge Mary Wagner, 30th Judicial District for the Western District of Tennessee. Today is Tuesday, April the 4th, 2023 at 9 a.m. The cases called for hearing today are case number 23-0336, Part 1, Metro Government of Nashville and Davidson County versus Bill Lee, Governor, et al., which is consolidated with case number 23-0395, Part 1, Davy Tucker, et al. Versus Bill Lee, Governor, et al. We will hear both cases today on motions for temporary injunction. Pursuant to Tennessee Supreme Court Rule 54, we are conducting today's hearing by Zoom video conference. With me in the courtroom is the Part 1 Judicial Assistant Kristen Mormon. Also on this call are Jordan Emily by Zoom. He is the 3-judge panel law fellow with the Administrative Office of the Court. Daniel Lane by Zoom with the 3-judge panel coordinator with the Administrative Office of the Court. I'm going to ask each set of attorneys to introduce yourself and any persons who are attending in the room with you by Zoom. I will begin with the attorneys for Metro Government.
Good morning, Your Honors. I'm Allison Bussell, Associate Director of Law for the Metropolitan Department of Law here on behalf of Metro Nashville. Also arguing, of course, subject to the court's discretion, I would like to divide my argument with Director of Law Wally Dietz, who is also here with me. And then also in the room are other counsel in this case, Melissa Roberge of the Metro Department of Law, as well as Bob Cooper and Mike Taka from Bass, Berry & Sims.
Okay, thank you very much. And representing the individual plaintiffs, whom do we have?
Thank you, Your Honors. This is Scott Tift with the law firm Barrett, Johnston, Martin, and Garrison, representing the individual plaintiffs, along with my colleague David Garrison, who is also on the Zoom, and will be joined by John Spraggins, who is also representing the plaintiffs. I'll be handling the argument, but the other two will be on the Zoom.
All right, thank you, Mr. Tift. And representing the defendants. We need to unmute, please.
Sorry, Your Honor.
No
Good morning. This is Timothy Simons. I'm one of the counsel for the defendants. In the room with me during the hearing will be Mr. J.P. Urban, who's my co-counsel. He will not be participating in the oral arguments. Also in the building is Mr. John Shirley, and we're going to ask that he be allowed to divide up the oral arguments with me, and he can. I think he's on camera. Thank you.
Morning.
All right. Is it Shirley?
Yes, Your Honor, John Shirley. I don't have anyone in the room with me. I'm next door to Mr. Simons and Mr. Urban.
All right, very good. Thank you. And we have a court reporter with us today. Would you please identify yourself?
Yes, my name is Betsy Peruki.
Thank you for being with us today. And should you be unable to hear anyone or have any issues, please just wave at us and we'll take a pause and make sure that we can address whatever issues are present. All right. Once we begin the hearing, I'm going to ask those who are not speaking at that moment to please mute your microphones. I think it will help improve the audio. That's been our experience with Zoom. Today's hearing is not an evidentiary hearing, but is oral argument that is being conducted on declarations, affidavits, and exhibits submitted by the parties. We will first hear oral argument on behalf of plaintiff Metropolitan Government of Nashville and Davidson County. 1 hour is reserved. Please let us know if you would like to reserve time for rebuttal. Next, we will hear oral argument on behalf of the individual plaintiffs in the consolidated lawsuit. An additional 15 minutes is reserved for your argument. Again, let us know if you would like to reserve time for rebuttal. And third, we will hear oral argument on behalf of the defendants for a total of 1 hour and 15 minutes to address the arguments presented in both of the lawsuits. Then we'll hear rebuttal argument first on behalf of Metro and then on behalf of the individual plaintiffs. One point of clarification before we begin arguments today, we received a notice from Metro government that it is withdrawing for purposes of today's motion. The issue of likelihood of success on the merits only as to count 1 of its complaint based on the Tennessee Constitution Consolidation Clause. Is that correct, Ms. Bussell?
Yes, Your Honor.
All right. And I would like to know, is that also, since the individual plaintiffs had adopted the brief of Metro government, is that also your position today?
Yes, Your Honors, it did. And for for a clean record, we filed a notice and couldn't get it in until this morning. So the record does note in a written filing that we are as well withdrawing that claim.
All right. Thank you for doing that. I had not seen that this morning. Also, just for the record, the panel had previously invited the parties to state their respective positions regarding consolidation of today's hearing with the trial on the merits. All parties have objected to that now. So today's hearing is not consolidated with a final hearing on the merits. All right. Are there any other preliminary matters that we need to address before we begin?
Nothing for Metro Nashville.
Mr. Tift?
Nothing for the individual plaintiffs, Your Honors. Thank you.
All right. And Mr. Simons?
Nothing for the defendants, Your Honor.
Okay, very good. And we are ready to proceed. Ms. Bussell, we'll hear from you on behalf of Metro.
Thank you, Your Honor. May it please the court. I would like to reserve 15 minutes for Metro Nashville's rebuttal.
All right. Thank you.
This court should enjoin implementation of the Metro Council Reduction Act, which is located at Chapter 21 of the 2023 Public Acts. Metro Nashville's 60th birthday was this past Saturday. Following the instructions set forth in the enabling legislation that authorizes the consolidation of metropolitan governments, Metro was to set the size of its own legislative body, and it did so in that charter 60 years ago. That charter created a 40-member Metropolitan Council that has served our city for 60 years. The irony of this birthday is not lost on me as we implore this court to enjoin this radical infringement on local sovereignty. I'm sure that the court is familiar with the 4 factors that should be considered when granting a temporary injunction. Mr. Dietz and I have divided the argument. I will be introducing the act itself, addressing defendants' standing and rightness arguments, and then arguing the likelihood of success prong for 3 of the 4 claims set forth in our complaint. Mr. Dietz will close the argument by discussing the harm prongs of the temporary injunction analysis. I'll first begin by describing what this act does. The Council Reduction Act, which is set forth at Exhibit C of our original motion, amends Title VII, Chapter 1 of the Tennessee Code annotated. The Tennessee Supreme Court has referred to that provision as the Metropolitan Government Charter Act. Following the adoption of the Home Rule Amendment, which I will discuss in just a moment, the General Assembly adopted this enabling legislation. And it outlines what cities and counties must do when they are electing to consolidate to become a metropolitan government. When adopted, that enabling legislation did not set a cap on the size of the local legislative body for a metropolitan government. It does now. Section 1A of the Metro Council Reduction Act sets a cap on the size of any metropolitan council at 20 voting members. And then Section 1B of the Act sets forth a very specific procedure for what a metropolitan government must do if its council exceeds that number of 20. Now, let's be clear. We all know why we are here. We all know that a council must shrink as a result of this act. One council, the Metro Nashville Council. So what does Metro Nashville have to do to effectuate this act? Well, by April 10th, that is within 30 days of the act becoming law, the Planning Commission must redraw district boundaries that don't exceed 20 voting members. Then by May 1st, the Metropolitan Council, the current Metropolitan Council, must vote on those districts. And then there's a trap door in Section 1B, 1A. If redistricting is not completed by the qualifying deadline for the next general election, then Metro's current council members have to serve an additional fifth year on their current term. And then their successors will serve a 3-year term after another election is held next year. The qualifying deadline under state law is May 18th. And importantly, there is no provision in that law for extension of that deadline. Time is of the essence because whichever districts are drawn and adopted as of May 18th will be the districts that proceed to election on August 3rd. That provides a nice segue to Metro's response to the defendant's standing argument. I want to begin by just noting that the state defendant's response effectively concedes standing for 2 of the 3 claims that I will be addressing today. The state argues that Metro Nashville has no standing to challenge the provision in Section 1B of the Act that extends the current council members' terms, and that is addressed in count 3 of our complaint. In support of this argument, the state says it affects council members, not Metro Nashville itself. Therefore, Metro Nashville has no standing to challenge the requirement. They argue this under the distinct and palpable injury prong of the standing analysis. This argument is easily dispensed with. First of all, this is a declaratory judgment action. So the bar to establish standing in such an action is a low bar. But more importantly, Metro Nashville legislates through its council members. When they act, Metro Nashville acts. Moreover, Section 1B of the Act is a lose-lose for the city. Either expend resources to draw a council map with half the current districts, which may be later overturned, or your council members have to serve an unconstitutional 5th year. That is, put all your other legislative priorities on hold to make space for this rushed, chaotic redistricting process with a constant flurry of questions and issues to address. And then actions that are taken pursuant to that new council, the illegally constituted council, because it's either the wrong size or because its members have served too long, would be subject to challenge. Again, Metro Nashville acts through its council members. And to suggest that Metro Nashville does not have standing because its legislators are the ones that would have to serve the additional year completely ignores these basic principles of democracy. State defendant's ripeness argument fails for similar reasons. The ripeness inquiry under the Declaratory Judgment Act is a two-part inquiry. First, are the issues fit for judicial decision now? And then secondly, what is the hardship to the parties if the court were to delay addressing the issue? Here again, defendants make only one ripeness argument. They effectively concede ripeness for two of the three counts that I will address in my argument. The one argument they do make is a head scratcher. They claim that Metro Nashville's arguments concerning the council term's extension is not right because the extended term only kicks in if the redistricting is not completed by May 18th. But the question is not merely when that trapdoor will open. The question is, what does the act require the city to do right now to comply with the act? The act is effective right now. And the act requires Metro Nashville to take extraordinary steps to comply right now. The State v. Price case that we cite in our reply brief acknowledges that on that second prong of the ripeness injury, the hardship prong, the prototypical case for hardship is where you are facing a choice between immediately complying with an illegal law or facing some sort of penalty if you don't comply. That's precisely where Metro Nashville stands today. The proverbial stick here that is causing Metro to expend significant human and financial resources to attempt compliance with this act is precisely why this case is ripe. Ripeness does not require present injury. It certainly does not require a fully realized injury. It merely requires a present dispute, and we are in a present dispute. The act is in effect. Metro must take steps to act to comply or risk the unconstitutionality of extended terms and then potentially face legal challenge for those. This claim is right. I'll now turn to the merits of the three individual constitutional claims that we are challenging through this motion. For purposes of the motion for temporary injunction, I'm going to focus on the merits of count 2, count 3, and count 4 of Metro Nashville's complaint. Count 2 asserts a claim under the local legislation clause of the Home Rule Amendment. Count 3 contains a claim arising under Article 7, Section 1 of the Constitution, specifically under the mandatory 4-year term for county legislative bodies. And then also under Article 7, Section 1, we assert a claim in count 4 challenging this act's conflict with the exemption for metropolitan governments from the 25-member cap on county legislative bodies. Any one of these claims warrants entry of a temporary injunction, but collectively, the need is even more compelling. Before I dig into each claim, I want to give the court just a quick overview of the history of the Home Rule Amendment, because it does provide some context for the argument. In 1953, there was a constitutional convention held in Tennessee, and that convention was primarily concerned with addressing the state's legislative abusive interference in local affairs. The Home Rule Amendment was adopted at that convention to address that very problem. That amendment, importantly, fundamentally changed the relationship between the state acting through its General Assembly and local governments, because now, as a result of that amendment, local governments no longer derive their power exclusively from what the General Assembly says. The Home Rule Amendment includes 3 different clauses, the local legislation clause being one of those. That takes me to count 2 of the complaint. Count 2 challenges the requirements in Section 1B of the Act to reduce the size of the Metro Nashville Council specifically. Our local legislation clause argument has two components. First, the prohibition against ripper bills set forth in that provision. And then secondly, the requirement that bills that are local in form or effect must be approved by the local legislative body. First, let's talk about the prohibition on ripper bills. This trapdoor provision in Section 1B is effectively a ripper bill. Paragraph 2 of the Home Rule Amendment is a very long sentence, but the first part of that sentence says the following: the General Assembly shall have no power to pass a special, local, or private act having the effect of removing an incumbent from a local office, or abridging the term, or altering the salary before the end of the term. There is no practical difference between cutting a term short and forcing an individual council member to serve beyond the term for which he or she ran and for which he or she was elected to serve. That is still the very type of tinkering with local officials' offices that the delegates were trying to shut down when they adopted this ripper bill provision. In our brief, we referenced Delegate Lewis Pope of Sumner County and his statement that, quote, the legislature cannot under any circumstances change the term of office for which an individual local official was elected, end quote. The court should conclude that this provision is effectively a ripper bill and that Metro Nashville has a strong likelihood of success on this claim. The second argument that we make under the local legislation clause relates to the local in form or effect language in that clause. This language, in fact, is the portion of the Home Rule Amendment that has been litigated the most. So we have plenty of law to draw from here. And all of it points in the direction of this law being unconstitutional. In Ferris v. Blanton, the Tennessee Supreme Court said, the question under this clause is whether a law, irrespective of its form, is local in effect and application. It is undisputed that Section 1B of this act affects only Metro Nashville. Only Metro Nashville must reduce the size of its council. Only Metro Nashville's council members must serve a fifth unconstitutional year of their term. Only Metro Nashville's council members who are elected on August 3rd, who are elected in a special election next year, will then serve a smaller term of 3 years in conflict with the Metro Charter. This provision will never apply to any other local government. The defendant's responses are twofold. First, the defendant says, well, it's not local in form or effect because subsection A of the act applies statewide. Well, we're not arguing that subsection A is local in form or effect. We're arguing that subsection B is local in form or effect. And Leach v. Wayne County makes very clear that this prohibition on local bills, it can apply to a portion of an act. You can't save something from Home Rule Amendment scrutiny by just burying a subsection that applies to everybody. That would completely defeat the purpose of the provision. The state's second argument is that the provisions in Section 1B, those are just transitional provisions that are necessary to effectuate the purpose of the act. Well, they aren't transitional provisions at all. The cases on which the state relies for this argument, including State Ex Rel Maynard v. Leach, Marion County Board of Commissioners, and again, Leach v. Wayne County, those cases permitted transitional provisions that conflicted with general law to effectuate a constitutional amendment, not the legislature's own act. Subsection 1B is local in effect. It contains no voter approval requirement. Therefore, under the plain terms of the Home Rule Amendment, it is null and void. Let's now turn to the two claims that we have asserted under Article 7, Section 1 of the Constitution. This provision was adopted at a different constitutional convention, at the 1977 Constitutional Convention. And the amendments in this article rewrote the article and set forth a general framework for how county government could operate in the state of Tennessee. The first claim that we make under this article is set forth in count 3 of Metro's complaint. And that is that the act violates the mandatory 4-year term for county legislative bodies in that article. Here's what the relevant constitutional language says. Quote, the qualified voters of each county shall elect for terms of 4 years a legislative body. Period. The list of offices that then follows that language are constitutional offices that Tennessee state law makes very clear cannot be abolished and cannot be tinkered with in this manner. The state defendants do not dispute that this provision applies to Metro. They have not disputed that. Their only response to this argument is, again, these are transitional provisions, but that's not what they are. Transitional provisions have only been upheld where they were necessary to effectuate a constitutional amendment. And that makes sense. Even when Metro Nashville was created, there was some tolerance in the case law for conflicts between what we were doing in our charter and what state law required. That makes sense when you adopt a constitutional amendment that sort of changes the rules. The legislature, however, doesn't get to claim the same authority. It can't change the rules in conflict with the Constitution. Section 1B of the Act sets terms for council members in conflict with this mandatory 4-year provision. The provision is unconstitutional. Our last claim is under count 4 of the complaint, and it also arises under Article 7, Section 1, and it's what we've been referring to as the exemption for Metro governments from the 25-member cap on county legislative bodies. This claim arises under the second paragraph of that section, specifically the 3rd and 4th sentences. The 3rd sentence limits the size of county legislative bodies to 25 members, but the 4th sentence explicitly exempts Metro governments from having a, quote, county legislative body as described in this paragraph, end quote. When adopted at the 1977 Constitutional Convention, Metro Nashville had already been operating with a 40-member council for 15 years. The state defendants argue that because the Constitution doesn't prohibit the General Assembly from setting a limit on Metro government council sizes, then it can set a limit. But that's precisely what this provision does. It doesn't call out the General Assembly by name, but it says the provisions of this paragraph do not apply to metropolitan governments. The provision that says the legislative body can't exceed 25 members doesn't apply to metropolitan governments. If that doesn't mean the General Assembly can't set a limit smaller than that, then what does the language mean? There is no other plausible reading of the 3rd and 4th sentences in conjunction with one another, other than to prevent the General Assembly from setting a cap lower than that number. In fact, they can't set a cap at all in light of this provision. Next, I will address the issue of severability, and this will only be an issue that the court has to resolve in a narrow circumstance, but I'm going to walk through that. If the court agrees with Metro Nashville that the act violates the exemption on the cap, the exemption on the cap as addressed in count 4 of the complaint, the one that I just referenced, then the court need not address severability, because that would mean that the entire act is unconstitutional because no such cap can be set. Severability is only relevant to Metro's arguments relating to Section 1B of the Act. That is the local informer effect argument under count 2 and the 4-year term argument under count 3. As we describe in our brief, Metro's position is that Section 1B is not severable from the cap in Section 1A because to elide it from the Act would frustrate the Act's purpose. The general test for elision is whether the remaining language can stand in keeping with the legislative body's intent. Would the legislature have enacted this law without the offending language? A severability clause can inform this, but it's not going to be enforced if it would frustrate the intent of the law. There is no stated or even discernible good faith reason why the General Assembly would impose these drastic measures on a local legislature that has existed for 60 years if the primary intent of the bill was merely to set a cap. Now, state defendants' response to this argument is, well, Metro would have to comply even if Section 1B were not included in the Act. Well, then why is Section 1B included in the Act? It's because the purpose of this bill was not to set a cap on all of these legislative bodies across the state that don't exceed 20. The purpose was to force Metro Nashville to immediately shrink its council in a rushed, chaotic, completely impracticable way. If the goal here were simply to set a cap, then the General Assembly would simply have set a cap, because it is not clear whether they would have adopted this act without Section 1B included. That section is not severable from the rest. I'm going to wrap up by describing to the court exactly what we are seeking. Because Metro Nashville is likely to succeed on all 3 of the claims that I have described, we would ask the court to enjoin this act in full. Here are a few paths that the court may choose. If the court agrees that metropolitan governments are exempt from any cap on the size of their local legislative bodies, as we argue in count 4, then the act should be enjoined in full, because sections 1A and 1B would be unconstitutional. In addition to that, if the court were to conclude that the severability clause cannot be enforced because it would frustrate the purpose of the act, then sections 1A and 1B are unconstitutional for any of the counts that we have asserted. But even if the court were to find a strong likelihood of success only as to the redistricting requirements in section 1B of the act, then the court should enjoin section 1B and should enjoin the act to the extent it requires Metro Nashville to take these unreasonable steps to redistrict before the August 3rd, the next general election. Thank you so much. And unless your honors have questions, I would like to turn the mic over to Director of Law Wally Dietz to discuss the harm phone.
All right, let me first ask Chancellor Bryant if you have any questions for Ms. Bessel.
No, thank you. No, thank you.
Wagner? Chancellor?
I do not. I don't have any
Ms.
questions.
Wagner? All right. I have one question, Ms. Bessel. If I could go back to your request for relief. You said if metropolitan governments are exempt, as argued under count 4, then the court should enjoin the act in full. Are you talking about the entirety of Chapter 21 or only section 1A and B of Chapter 21?
That's a great point, Your Honor. I have been focusing only on section 1 because that is the portion of the act that applies to metro governments, and that is the exclusive portion of the act that we are challenging. So we would.
And let me just clarify a little bit further. What is your position with regard to 1C that applies to metropolitan governments in the future?
Our position on 1C would be the same because the Constitution contains an exemption. We would argue that that exemption prevents the General Assembly from setting a cap on metropolitan governments at all, whether they're formed now or formed in the future.
And the reason that I ask that is there are additional sections under chapter 21, section 2, which pertains to municipalities. And you're not making any argument today with regard directed to section 2. Is that correct?
That's correct. Yes. And thank you for, I think that's a great clarification. I appreciate Your Honor bringing it to my attention.
All right. Thank you very much.
Thank
That's
you.
all I have.
Good morning, Your Honors. And may it please the court. I'm Wally Dietz, Director of Law for the Metropolitan Government of Nashville and Davidson County. In my position, under the charter, it's the responsibility of the law director to represent the interests of Metro as a whole, not just the mayor, not just the council, not just the department heads. The law director is here to represent the interests of the metropolitan government as a whole. We are here today because the Metro Council Reduction Act is an assault on the very core of the metropolitan government itself. The right of local citizens to pick the size of its legislative body and the right to select their legislators, many of whom are facing elimination of their jobs because the council size is ripped in half. We're here to protect the interests of all of them. The state argues that its interests are harmed when courts enjoin an act of the legislature. Well, if you take that argument to its logical extreme, that means the courts can never rule against an act of the legislature. That's simply not how our three branches of government work. The courts have a critical role to play, especially in a case of egregious legislative overreach. Implementation of the act is causing and will continue to cause irreparable harm to Metro and also to the public interest. Courts routinely hold that a violation of a constitutional right mandates a finding of irreparable harm. In our briefs and supporting documents and the arguments of Ms. Bussell, we have established that this bill, this legislative act, is fatally flawed based on several provisions of the Tennessee Constitution. That alone should be sufficient to prove irreparable harm. But the harm here goes actually beyond just a constitutional violation. Metro is a unique city, and that dates back to our very inception. And that history highlights the act's harmful effects. Soon after the 1953 convention, officials in the city of Nashville and officials in Davidson County began discussions about consolidation. A referendum to consolidate was placed before the voters in 1958, and it was rejected by the voters. Most people believe that one of the main reasons it was rejected was because African-American voters were very concerned that the size of the council, which under that charter was 21, that size would not provide for adequate representation. So we're 4 years later, in 1962, the voters did approve a charter which created a council of 40 members. The Metropolitan Government of Nashville and Davidson County opened on April 1, 1963. There was a grand celebration just one block from here at the Municipal Auditorium, where people celebrated the opening of our metropolitan government. That first council had 5 African-American members. They are now regarded as some of the giants of Nashville history. Metro Council has had 40 members for 60 years. The fact that our council fairly reflects the diverse community that exists here in Nashville is a point of pride for all of us who make our home here. This bill raises serious concerns, whether that can be maintained, whether it raises concerns about the Federal Voting Rights Act. And those concerns are expressed in letters both from the IMF and from a group of Latin American civic and business leaders. Those letters were submitted with our moving papers. When we talk about home rule, we're talking about the people here in Nashville, people who made the decision about where they want to live. Some of us, like me, were born here. Many others moved here from another place because they wanted to make their community here, build a life here. This is where we live. This is where we work. This is where we raise our families and make friendships. We should be the ones to decide how big this council is and how those seats are allocated. That's what home rule means. The impossible timetable in this act is already causing irreparable harm and damage to the public interest. We are already well into this election. Ms. Bussell has gone over a lot of the deadlines in the act, and I won't repeat those. We're less than 4 months away from this election, almost barely 3 months away from the start of early voting. And so take a step back 1 year after the 2020 census, which required us to redistrict state offices and local offices. Metro Planning Commission conducted months of listening sessions, community group meetings to figure out how best to come up with a council that reflected the community. That result got rave reviews. There was almost no controversy about that. So in January of 22, 15 months ago, the council adopted maps for the Metro Council race, which is coming up right now. We are in it right now. Several candidates appointed treasurers and started raising money immediately. As of the January 15th financial reporting reports, those candidates had over $500,000 in funds still on hand. New disclosures will come out in 11 days, and that number will be significantly higher. 15 days ago, the Election Commission, between a rock and a hard place, went ahead and issued petitions for the 40-member council, 35 district seats plus petitions for the at-large seats. And so even though the qualifying deadline is just 44 days away, because of this act, no one, not the candidates, not the incumbents, not the voters, no one has a clue today what council district they will be in for this election. The act requires the Planning Commission to provide a map by April 10th, and community input has been really difficult on a meaningful basis. The council meets again tonight to decide what direction, if any, to give to the Planning Commission. What's problematic is this bill, because it was done in haste and recklessly, actually establishes two deadlines for the council to act. The first deadline is May 1st, where it says the council must approve a map by May 1st. But there's no remedy or consequence if the council doesn't do that. What happens with this trapdoor provision is that if the council does not adopt the map by May 18th, the qualifying deadline, then we are automatically into this very dangerous, unconstitutional mechanism to have a fifth year for our council. The council doesn't have time to fully assess its options. That was made clear in the Bob Mendez declaration. We do have a great planning team, but even as good as they are, it's impossible to do this the way we should. And as federal courts have said in Voting Rights Act cases, a quick plan is not necessarily a good plan. And that's true here. Candidates are going to be faced with getting new maps, figuring out what district they're in, and then starting over, getting petition signatures from 25 voters, and they will have either 0 to 17 days notice to do that, depending on when the council adopts a map. Then, after May 25th, with the deadline for candidates to withdraw, the Election Commission must print new voter registration cards with the new districts. For those of us who vote in Nashville, that means in the last 12 months, we will have had 3 different voter registration cards. the one prior to the 2020 census, the one based on maps that were adopted a year ago, and this new one. That alone is going to create mass confusion. People were confused about the new districts last year in the election, and they had several months of notice. Putting this additional burden on the election commission and to send out new cards, people will absolutely be confused. It is simply too late. It's not fair to the voters. It's not fair to the candidates who have already invested and raised hundreds of thousands of dollars for districts that will no longer exist. None of the existing districts will exist. They will all be changed into larger districts with a smaller number of seats. The integrity of this election is dangerously at risk. This case is crying out for injunctive relief. This is why we have rules for this. The court need only look to the decision of the Tennessee Supreme Court almost exactly 1 year ago. In that case, Moore versus Lee, certain voters filed a complaint saying that the lines that the legislature drew for the state Senate districts in Davidson County were unconstitutional because they were not sequentially numbered as required by the Constitution. In March of 2022, a three-judge panel, just like Your Honors, agreed with the plaintiffs, said that that was a clear violation of the Constitution, and the court issued an injunction saying, we're not going to enforce that. The court ordered the legislature to draw new maps within 3 weeks and ordered an extension of the filing deadline to let that happen. So what happened is that after issuing that injunction, the Supreme Court, on its own motion, reached down and took the case and said, we are going to resolve this case without additional briefing, without additional argument. This is a critical issue because we are in the middle of an election. The Supreme Court took incredibly unusual steps to make its decision. And on April 13th, the timing is important here. On April the 13th, today is April 4th, the Supreme Court issued an order vacating the injunction, citing concerns to the disruption of the ongoing election cycle. The court, in that case, the Supreme Court, didn't even get to the merits of the constitutional claim. It said the damage is being caused by the chaos in this election. And so while we strongly believe that our constitutional claims, all of them, give grounds for an injunction, this court can do it without addressing those. We believe those constitutional claims should be resolved just to create law about the relationships between the legislature and local governments. The Supreme Court looked at several issues. The uncertainty and confusion that will result in a change in the plan. The court cited a 2006 U.S. Supreme Court case. It's the Purcell Doctrine. It came in Purcell versus Gonzalez, where the Supreme Court there stressed the confidence and integrity of our electoral process is essential to the functioning of our participatory democracy. That is the U.S. Supreme Court speaking. Citing concerns of changing the rules on the eve of the election, the court said that changing those rules that late in the game, quote, can themselves result in voter confusion and consequent incentive to remain away from the polls. And so even when federal courts in Voting Rights Act cases found that plaintiffs had a likelihood of success on the merit, many of those federal courts refused to issue an injunction because the election was already going on. In the Moore case, the Tennessee Supreme Court said robust evidence of the harm the plaintiffs had, the state had put forth, robust evidence of the harm that will result from delaying the election. We have made that case here. Unlike Moore, we don't have a challenge. We don't have a change in the filing deadline, but we do have a change in getting the petition deadline and getting the signatures. Normally, that time period is 60 days. It may be reduced to 17 or theoretically even fewer than 17 days. So pre-filing deadline candidates and voters are losing the opportunity that state law provides. So we believe Moore is all fours on this case, and that alone, based on Moore, this should be enjoined. It's disrespectful to the voters, to the election process, to the candidates. It should be enjoined. So the Supreme Court said that we are vacating the injunction. We're going to let the election proceed as it was originally planned. Moore is, at its essence, an injunction case. Injunctions are designed to prevent harm to a party or to the public interest. The nature of the injury does not change based on who the actor is. It doesn't matter which branch of government generates the harm, whether the governor, the executive branch, the legislative branch, or the courts. It doesn't matter. Moore was focused on the harm. This court, we ask to focus on the harm that this is causing. We have demonstrated irreparable harm. The public interest strongly favors, in fact, it compels the issuance of an injunction. Finally, let me close with a quote from a brief. This is a brief where the headline of the section says, plaintiffs' requested relief will cause substantial harm to the state and will not further the public interest. The lawyers go on to argue here, the election process for members of the House of Representatives and Senate is well underway. Qualifying petitions for candidates for the General Assembly began to be issued on February 7th. The qualifying deadline for candidates is April 7th. The withdrawal deadline is April 14th. In order to qualify for candidacy, the candidate must present a petition to the Election Commission containing the signatures of 25 registered voters in the district. Emphasized. Candidates cannot obtain those signatures unless they know where the district boundaries are. Plaintiffs are asking the court to change the rules in the middle of the game. Well, you might think that was one of our arguments, one of our briefs, but no, that was the argument from the Tennessee Attorney General 1 year ago in the state Senate redistricting case. We agreed with the Tennessee Attorney General in their opinion 1 year ago in the Moore case. It is simply too late. We're asking this court to issue an injunction of this act to protect our constitutional rights, to protect the integrity of our elections, and to prevent irreparable harm. Thank you. If there are no questions, we'll reserve the balance of our time.
All right, thank you very much, Mr. Dietz. Chancellor Bryant, do you have any questions?
No, thank you.
Judge Wagner, do you have any questions?
I do not. Thank you.
All right, and nor do I. Thank you, Mr. Dietz. We'll reserve
Thank you,
the rest of your time. All right, we will move to the individual plaintiff's argument. Mr. Tiff, are you presenting?
Yes, Your Honors, I am presenting, and may it please the court. My name is Scott Tift, represent the individual plaintiffs in this case, and we would reserve 3 minutes for rebuttal out of our 15. We're here today representing individual plaintiffs who are pursuing the same claims as the Metro government, and it's an important distinction that I want to highlight right from the get-go. The plaintiffs here are 8 active, involved voters, candidates, and electeds from across the Metro geography, representing the diverse community that Director Dietz was just speaking about. We have faith leaders and community leaders and Reverends Davey Tucker and Reverend Dr. Judy Cummings. We have a business leader, former Commissioner of Finance and Administration, Dave Getz, longtime community activist from Southeast Nashville, Alma Sanford, non-incumbent candidates for Metro in Quinn Siegel, who's seeking an at-large position, who's raised over $78,000 and been campaigning for months, and 3 incumbent Metro council members who are seeking re-election, 2 district members, Delicia Porterfield and Sandra Sepulveda, and 1 at-large council member, Zulfat Suara. We highlight that because it's important that first and foremost, what all 8 candidates share is that they are voters in the Metropolitan government. They have attested to their facts through sworn affidavits or declarations that they do live in Davidson County, have voted, do vote, and intend to continue voting regularly, if not in every single election. So fundamentally, we have voters bringing these claims, Davidson County voters. Now we also have candidates, both incumbent and non-incumbent, and members of the Metropolitan Council. And we think that is highly important as we move to the question of standing. Now, first off, it's important to note that the court need not reach any standing objections as to the individual plaintiffs on 2 of the 3 claims, because as Mrs. Bussell has already made clear, the Attorney General's office, the defendants did not challenge Metro's standing on 2 of the 3 claims here. They only challenged Metro's standing on the 4-year term provision. So on the posture of a temporary injunction, the court has plaintiff was standing before it on those 2 claims and need not at this point adjudicate whether or not the individual plaintiffs have standing. And that's either on the local legislation clause or on the Article 7, Section 1 exemption from a maximum number of candidates clause, because Metro is here with undisputed standing. Now, that's not to say that the individual plaintiffs do not have standing. I mean, most briefly on that point, on the local legislation clause, the way that clause works is that should local legislation be enacted by our General Assembly, it must then be ratified by either the council or the people. And these are voters who have a right to ratify a gross reach down into the local government of Metropolitan Nashville. So the plaintiffs do have standing, we argue, on those 2 claims, but are not going to speak much more about it, given that it's uncontested that the Metro government does, and we're not here on a motion to dismiss or even on a subsequent permanent injunction or longer term injunction footing. Now, Metro, or rather the state, the defendants do contest Metro's standing on the 4-year term, pointing out in their brief, while not conceding, making the point that Metro, and this is from the defendant's response to Metro's motion, is, quote, asserting the rights of and alleging injury to others, voters, incumbent council members, and council members yet to be elected. That's who these plaintiffs are. That is the individual plaintiffs. They are the ones bringing this. And so we're going to walk through how the voters have a right under their constitution that gives them standing to challenge the legislature's decision to extend the term by a year of council members. As Ms. Bussell has already walked through for the court, the Constitution in Article 7, Section 1 clearly states that these constitutional local legislators shall serve 4-year terms. There's no language about surplusage or filling in until another person is in the seat. It shall serve 4-year terms. And the voters are being disenfranchised by any statute that prevents them from renewing their legislature every 4 years as governed by a 4-year term restriction in the Constitution. These current council were elected for 4-year terms, and the Constitution and our representative democracy limits that at 4-year terms, giving the voters who have their fundamental voting right the right every 4 years to keep people if they want to re-elect somebody who's not term limited, to reject someone who's not yet term limited, or to elect new people. That is the fundamental voting right that stems from a 4-year term requirement. And it's important to also point out that the fact that these 8 plaintiffs share that injury with the other voters of Davidson County does not undermine standing. That's fundamentally the case in many voting cases, redistricting and otherwise, that while the injury is typically not shared with voters generally across an entire state, the injury is fundamentally shared with some number of people, because in any sort of challenge of this type, you're going to have a subset of voters who are treated differently than the voters of the rest of the state. Looking to the United States Supreme Court in Baker v. Carr, which of course we all know arose from the state of Tennessee, the United States Supreme Court noted that that voters in certain counties, when a bill puts them in a position of constitutionally unjustifiable inequality vis-a-vis voters in irrationally favored counties, that gives them standing. That Baker v. Carr was a justiciability question from the get-go. Previously, challenges had been considered part of the quote political thicket, and courts had deferred from getting into redistricting or gerrymandering challenges. But in Baker v. Carr, the court here expressly says that when you're being treated in a constitutionally unjustifiable way, unequal vis-a-vis other voters, that you have standing to bring the claim. That's what we have here. The metropolitan government, the citizens of Metro Nashville are being treated in an unjustifiable way constitutionally vis-a-vis the voters in the rest of the entire state. Certainly in the other two metropolitan government counties where voters aren't being required to have their legislators serve an unconstitutional additional term, but throughout the entire state. Baker v. Carr goes on to state that in certain counties, voters were disfavored relative to voters in other counties, and that gave them standing. That's the situation we're in. And it's, again, not novel when you look at our state's jurisprudence on redistricting. We've had all sorts of cases where people in the affected district who are being disfavored as opposed to other districts have standing. A long line of cases about whether or not counties can be divided in redistricting under the Tennessee Constitution, most notably in what is referred to as the Lockhart trilogy from the 1980s, but also proceeding through subsequent decades. Did someone say something? Oh, sorry, I heard some noise on the background. In those cases, everyone in a county that has been unjustifiably split shares the injury of a unjustifiably split county. In contiguity cases, everyone in a part of the county that's not contiguous with the rest of the district shares that injury. And it's fundamental to these kinds of cases that the injury is shared. And in all these kinds of cases, the voters are still allowed to vote. The AG's office, the defendants argue, well, these citizens are still able to vote and they share their injury generally. And the case law just doesn't play that out. If you're being disfavored in violation of the Constitution vis-a-vis other voters, and if you're in a disfavored district, you are still able to vote, but your vote has been unconstitutionally disfavored, giving the individuals the standing. And so it's important to note that the difference between standing and defendants asserting a defense. The Constitution says that the terms are 4 years. The terms are being extended beyond 4 years. That is what gives standing. Defendants have a defense. They claim this is a transitory mechanism, and the individual plaintiffs fully agree with, and of course have incorporated the arguments of Metro on that point. But the fact that there may be a defense to an extension of the 4-year term does not undermine standing. It's a defense. The standing is established because this statute extends the term beyond the constitutionally required term, therefore depriving the voters of their right to vote every 4 years. I'm trying to check my timer here real fast to see where we are, 10 minutes. Okay. And so finally, I wanted to point out how plaintiffs bear the harm and reflect the public interest in a way that only individual people can do. It is absolutely the case that Metro it suffers harm itself as a government. What could be more harmful than an unconstitutional government existing for a year or for longer, where every single act is subject to legal challenge and perhaps reversal? That is certainly an injury. But individual voters suffer one of the most fundamental constitutional deprivations in our jurisprudence, which is the loss of the right to vote. One thing that defendants point out in one of their briefs is essentially there's no problem here because you can just have a special election if anything it is either deemed to be constitutional or unconstitutional. They walk through each option and note, but then there could be a special election, so no harm. Well, a special election doesn't remedy the harm of having your vote taken away from you. A special election after August of this year means that these voters did not get to exercise their right to vote for a new Metropolitan Council at the end of the constitutionally prescribed 4-year term. That is fundamentally a harm, and having a special election 6 months later doesn't remedy the fact that their right to vote on a new Metropolitan Council was taken away in August of 2023. And finally, like Director Dietz, we would point to the Moore v. Lee case and wanted to highlight that the fact that the Purcell doctrine has typically, if not always, come up in cases where a court has issued an injunction requiring redistricting doesn't alter the fact that our Supreme Court has validated the exact harms articulated by the Metro government and by the individual plaintiffs of a hopelessly rushed and chaotic election. Of course, that harm falls in a very individual and very important way on individuals who have a right to vote in a well-run election. But I'm going to read what may be a little bit longer of a block quote than people advise reading in an oral argument. But this is our Supreme Court, based on a sworn declaration from defendant Goens's assistant about all of the fundamental problems on this exact schedule of requiring redistricting after now. Our Supreme Court states these affidavits, meaning those of Beth Henry Robertson and a few election commissioners, set forth in robust detail the myriad responsibilities our state and county election officials have in ensuring an orderly election process and the timelines under which they must satisfy those obligations. For example, Mrs. Robertson explained in her affidavit how statutory deadlines for candidate withdrawal and disqualifications are tied to the April 7th qualifying deadline, and how those deadlines in turn impact the ability of election officials to satisfy the requirements for military and overseas citizens ballots under the Military and Overseas Voters Empowerment Act. Ms. Robertson further detailed the impact of these deadlines on the preparation, review, and approval of ballots pursuant to Tennessee Code. She also detailed the multitude of other tasks that election officials must accomplish in the time leading up to election, including setting up electronic databases of candidates, training election officials, and administering examinations for election administrators seeking certification as required by the Tennessee Code. It goes on and on based on the sworn testimony of the people who are tasked in our state with running our elections to then summarize, quote, "We find that alleged harm is outweighed by the significant harm the injunction will inflict on defendants and the public interest." Our election officials, based on their sworn testimony, have now been validated by our Supreme Court that doing an election on the a reapportionment and redistricting, two different things, picking how many seats and then setting those seats on this schedule is contrary to the public interest, which is of course the fourth part of the temporary injunction standard, and speaks to the harm to voters who have a right to vote in a well-run election devoid of the kind of chaos that functionally deprives individuals of their right to vote. Our Supreme Court has validated that based on our election, state election officers' sworn testimony. So the factors do support temporary injunction. And just as we've incorporated the written arguments of the Metropolitan government, we also stand by and incorporate all the oral argument today as if stated on the individual plaintiff's behalf for the underlying legal issues beyond those about the specific situation of our individual plaintiffs. And with that, at what I think is approximately the right amount of time, we yield absent questions from the panel.
All right, thank you, Mr. Tift. Chancellor Bryant, any questions?
No questions.
Judge Wagner, any questions?
No questions.
All right, and I don't have any either. Thank you, Mr. Tift. We will now turn to the state's arguments. Mr. Simons, you'll be arguing on behalf of the state.
Yes, ma'am. Good morning. May it please the court. My name is Timothy Simons, and I represent the defendants in this consolidated action. The plaintiffs have filed motions for temporary injunction seeking to enjoin the enforcement of Chapter 21 of the 2023 Tennessee Public Acts, pending a final decision by the court on the plaintiff's constitutional challenge of the statute. During the course of my argument, I will refer to the statute as the Act for simplicity purposes. The defendants oppose the plaintiff's motions for temporary injunction and request that the court deny those motions. We are also contesting the legal standing of plaintiffs to assert many of the constitutional challenge claims that have been put forth. And my co-counsel, Mr. Jonathan Shirley, will address those at the conclusion of my presentation, if the court will allow that.
Of course.
Thank you. As a general matter, in getting into the discussion of the grounds for the request for injunctive relief, I think it's important to put in the proper context what the legislature's authority is with respect to local governments. And in the case of Leach versus Wayne County, which has been cited in all the briefs, the Tennessee Supreme Court makes it clear that the General Assembly has very broad powers and discretion with respect to the structure of local governments, which would include metropolitan governments. And pursuant to that broad authority that the legislature has, the General Assembly passed the act, and Governor Lee signed the act into law on March the 9th of this year. And the act generally amends Chapter 1 of Title 7 and Chapter 53 of Title 6 of the Tennessee Code by establishing a cap of 20 voting members for metropolitan government councils and a cap of 20 voting members for the governing bodies of municipalities. And the laws governing the formation, structure, and operation of metropolitan governments are found, as we know, in Title 7, and the Title 6 applies to municipalities. And under the act, all metropolitan governments must implement the cap, the 20-member cap, as of the next general municipal metropolitan election after the act's effective date. And as we've mentioned in our briefing, there are certain transitional provisions that are applicable to any metropolitan government that's required to reduce the number of its voting members on its council to comply with the 20-member cap. Specifically, the act says that if there's a reduction necessary to achieve compliance with the act, then the metropolitan government must take necessary legislative action to approve and put into place redistricting prior to the qualifying date for the next general election. And in the scope of who is covered by this act, it's important to point out that there are 3 metropolitan governments in the state of Tennessee, including Davidson Metro. You have the Lynchburg, Moore County, and Hartsville, Trousdale County. Now, at the present time, as we know, Metro Nashville has 40 voting council members. Hartsville, Trousdale has 20 voting members, and Lynchburg, Moore County has 15 voting council members. And also with respect to Section 2 of the Act, which deals with municipalities, there are over 300 municipalities in the state that are governed by this Section 2 of the Act, as well as the other provisions of Title 6. So I wanted to put that in the context of what the scope of this act is and the fact that it's applying to a number of metropolitan governments as well as hundreds of municipalities. Now, let's discuss the applicability of this act to Metro Nashville. As we know, the next metropolitan election is August the 3rd of this year. And the qualifying deadline for that election is, as previously discussed, May the 18th of this year. So in applying the act to this specific circumstance, the act requires Metro Nashville's Planning Commission to establish new district boundaries within 30 days after the effective date of the act. And Metro's council must approve the new council district boundaries that comply with the act, limiting it down to 20 districts by or less by May 1st, 2023. If Metro Nashville fails to comply with the May 18th or May 1st deadline, then the alternative transition provision kicks in, which basically extends for a year Metro's ability to redistrict and requires for a special election in August of 2024 to effectuate the redistricting requirement of the act. And also, as a transitional provision, the existing council members' terms are extended for 1 year. until the August 2024 election. And then at that time, there will be a 3-year election or 3-year term for those elected there as part of the transition to get Metro back on a regular election calendar. So that's the way that the act applies to Metro with regard to its election calendar. I'd like to discuss the plaintiff's challenges to the act in a summary form. First of all, they have 4 counts in their complaint. The first of the count is count 1, that they say the act violates the consolidation clause in Article 11, Section 9 of the Constitution. That is not part of the arguments that are being presented by the plaintiffs in this case. It's not part of this motion, but obviously I wanted to point it out that it is part of their claim. Also, they claim that the act violates the local legislation clause found in Article 11, Section 9, that the act also violates the 4-year term requirement in Article 7, Section 1. And they also claim that the act is inconsistent with the provisions of Article 7, Section 1 that exempt metro governments from the 25-member cap of county governments. Contrary to the plaintiff's assertions, we contend that the act is fully constitutional and that there are no grounds for the granting of a temporary injunction under Rule 6504 in the present case. I'd like to now just address the elements for analyzing the injunction claim that the plaintiffs have presented to the court. As we know, there are 4 elements that must be looked at by the court when deciding whether a motion for temporary injunction should be granted or denied. The first is the probability that the requesting party will succeed on the merits, the threat of irreparable harm to the party requesting injunctive relief if the injunction is not granted, the balance between that harm and the injury that granting the injunction would inflict on the party opposing the relief, and then lastly, the public interest. And it's also important when ruling on these motions that the court need not take facts in the complaint as true or view all facts in the light most favorable to the plaintiff when adjudicating the motion for temporary injunction. So I'd like to address the first prong of this analysis regarding the likelihood of success on the merits. And we believe that the plaintiffs do not have a likelihood of success on the merits with regard to their constitutional claims that are mentioned in the motion. The first point I want to bring out on this as part of analyzing this is that there's a strong legal presumption that enactments of the Tennessee legislature are constitutional. And that's a strong presumption in favor of the constitutionality. And the courts have a duty to save insofar as constitutionally permissible legislative enactments when a statute is susceptible of 2 constructions or interpretations, one which will preserve and one which will destroy. That must be given it which will preserve it. And due to the strong presumption that acts of the General Assembly are constitutional, the party attacking the constitutionality of a statute bears a heavy burden in establishing some constitutional infirmity of the act. So in light of that strong presumption of constitutionality, affects the lens by which the court should look at this motion for temporary injunction. I'd like to first address, with regard to the constitutional claims, the local legislation clause argument in Article 11, Section 9, which is in count 2 of their complaint. In essence, the plaintiffs claim that the act violates Article 11, Section 9, and what is commonly called the Home Rule Amendment. And in Metro Government versus Tennessee Department of Education in 2022, the Tennessee Supreme Court laid out the elements that you must prove in order to establish a claim to challenge a statute as for violating the Home Rule Amendment. There are 3 elements that must be proven. 1, that the act is local in form or effect, which is text right out of the constitutional provision. The act is specifically applicable to Metro Nashville in this case, and the act is applicable to Metro Nashville in its governmental or proprietary capacity. And so the issue of which we've briefed and we've discussed in this in our filings is the concept of whether this act is local in form or effect with respect to Metro Nashville. In Ferris v. Blanton, the Tennessee Supreme Court discussed various guidelines to use in deciding whether a suspect legislative enactment is local in form or effect. And in that case, the Supreme Court ruled that the purpose of the Home Rule Amendment is not based on the outward, visible, or facial indices, nor the designation, description, or nomenclature employed by the legislature. Rather, the sole constitutional test must be whether the legislative enactment, irrespective of its form, is local in effect and application. But the court went on to say that not every statutory provision affecting a single local government would run afoul of the Home Rule Amendment. The court must determine whether an act was designed to apply to any other local government in Tennessee, for if it is potentially applicable throughout the state, it is not local in effect, even though at the time of its passage, it might have applied to only one local government. And so those are the guidelines that the court should use when analyzing whether this act is local in form or effect as to Metro Nashville. And we also, with regard to that rule and that standard, it's also important that you take the statute in its entire context, looking at the entire context of the rule as to its applicability when making that determination. And in Civil Service Merit Board of Knoxville versus Burson, which we cite in the brief, the Tennessee Supreme Court also went on to note that the fact that one local government, if the statute applies to multiple local governments, but there's one local government that must take affirmative action to become compliant with the mandates of the statute. The mere fact that they may have to take an action, whereas other affected metropolitan or governmental bodies are already in compliance and really have to take no action, that is not a telling indication that it's local in form or effect, as long as the mandates of the act apply to all of them going forward. So in a situation of our case, where we have the two other metropolitan governments that are technically complying with the statute now, it does affect them because they are proscribed from extending their membership past the cap that's established in the act. So it does affect them. It is, and because of that, the general provisions of the act establishing this 20-member cap for metropolitan governments and for municipalities is not of local effect, and therefore should be viewed as being a statute of general application, which is well within the legislature's broad authority to enact to affect the structures of local governments. I also wanted to point out that this also will apply not only to the other two metropolitan governments, but all future ones that may be organized in the state with regard to the cap on the voting council members. And as the Chancellor pointed out, Section 1C addresses that point, where it says that all future metropolitan governments would be bound by this as well. And that's another one of the tests that the court uses to see the prospective application for new governmental bodies that might come into existence after the statute's enacted. So those factors that you look clearly establish that this is not of local form and effect, is a statute of general application, and it's a constitutional enactment by the legislature. Now, the plaintiff's focus in this argument is to say, well, you really need to look at 1B, because 1B, I think we all acknowledge 1B has specific applicability to Metro Nashville, because they are the only current municipal government that is not in compliance with the statute. So therefore, they have to take those actions required in 1B to achieve compliance. But the issue there with regard to the plaintiffs argue therefore that, well, this specifically applies to Metro Nashville, so it's of local form and effect and therefore unconstitutional under the constitutional provision we're talking about. And in light of that, as we point out in our brief, that's just not the legal standard that's used. And we've cited the court to a couple of cases, Leach versus Wayne County and Manor versus Leach, which discuss this concept of implementing transitional provisions as a way to achieve compliance by individual local governments to assist in getting them in compliant with the statute because of the unique circumstances of an individual situation. And in light of that, I think Metro Nashville has tried to argue that those cases that we've cited stand only for the proposition that only affects, and you're only allowed to use these types of transitional provisions as part of when there's a constitutional change, and the legislature is merely enacting laws to effectuate those constitutional changes. We respectfully submit that the language and the holdings of those two Supreme Court cases are much broader than that. And in light of this, what we talked about previously, the broad authority of the legislature to enact laws affecting the structure of local governments, that those holdings of those cases should be construed to allow these transitional provisions to be enacted whenever the legislature is enacting these types of restructuring acts pertaining to local governments. They certainly have that within their purview to enact these transitional provisions to get everybody moving towards the same final conclusion. And it just so happens with Metro Nashville, because they have a general election coming up this year, this act is intended to get them into compliance in a reasonable fashion. And that's why they have alternatives. They have the alternatives of either trying to do it by the August 2023 election or giving them an additional year to do that. Those types of transitional provisions pursuant to those the cases in Leach versus Wayne County and Manor versus Leach clearly show that the Supreme Court has recognized the usefulness and utility of those, and also that the legislature does have the authority to enact those. In fact, in the Manor versus Leach case, the court was discussing this argument, which is, oh, well, very similar. 1B, it only applies to Metro Nashville, therefore it's of local form and effect, and it should be viewed as unconstitutional. And then the Supreme Court in Manor v. Leach says, well, no, because if you have a general authority to restructure governments and there are individual circumstances where they're going to require some additional included amendments or additions in the statute to achieve compliance by certain individual local governments, that's fine. That's within the purview of the legislature's authority. So to that extent, we believe that the act, including 1B and 1A, coupled with the other provisions of the act, are certainly constitutional and do not violate the home rule amendment that's in the Article 11, Section 9. So that's our first argument with regard to that. The other argument it relates to the same constitutional provision, but there's the argument that they claim this act constitutes a Ripper bill because it somehow takes incumbents and shortens their terms, or it affects in some way their terms or salaries. And clearly from the express language of the act, this act does nothing of the kind. If in fact the first transition provision is complied with and they have a general election in August of 2023, then there will be normal elections for 4-year terms in accordance with the normal election calendar that Metro Nashville uses. But if there is not compliance by the May 2023 deadline, then the 1-year extension comes in. But that doesn't infringe on the existing terms of incumbents, as that term incumbent is used in the constitutional provision. It merely includes an extension of that term. It's not mandatory. The council member doesn't have to serve in it, but it's a way of transitioning so that we can eventually get back on the regular scale. And then the 3-year term that's would be the product of the August 2024 election, as the court has mentioned, is not, and we'll get into that later as far as the 4-year term, but these are all mechanisms that are used, and none of these affect the incumbents, the current incumbents. It doesn't shorten any of their terms. It doesn't affect their salaries. It doesn't affect anything with regard to the issues that are intended to be protected by Article 11, Section 9. So we don't think that this constitutes a ripper bill. It doesn't rip any incumbent from office or shorten their term. And that's the focus of that constitutional provision. Then with regard to the next argument in count 3 of the plaintiff's complaint, this issue that Article 7, Section 1 of the Constitution has been violated by the Act because of the 4-year term provision. This is one that relies on very similar case authority that we cited earlier. And I'll just briefly address this issue regarding the rightness. We've asserted in our briefing that the challenge of the 4-year provision and the Act under that is not right for adjudication at the present time, because that triggering hasn't happened yet. That 1-year extension only comes into play if the May 2023 deadline is not met by Metro Nashville. And we cited in our brief numerous cases that stand for the proposition that when you're challenging a statute or a part of a statute, the courts are reluctant to address those constitutional questions and adjudicate those if, in fact, they're not truly before the court and there's other ways to resolve it short of deciding that question. And our position on that is, Your Honors, that this is a situation where clearly the first step transition is justiciable, and we're arguing about that right now. But with regard to the trigger of the second part, the 1-year extension, that is not before the court yet. It hasn't gone into legal effect yet because of the triggering mechanism. And under the case decisions that we cited in our brief, talking about judicial restraint when adjudicating or deciding constitutional challenges, that is not an issue that should be addressed yet, and only when it becomes truly before the court and the event has been triggered. So, as we know from the record, Metro has been moving forward with redistricting maps and have been taking efforts. So there's still, from what we can tell in the record, a possibility that they may actually meet the May 2023 deadline. So in light of those, we think that that's not right for adjudication at the present time, the alternative 1-year extension provision. Alternatively, though, if those arguments are right for adjudication, we don't think that those alternative provisions violate Article 7, Section 1. And as we've discussed before, this relates to the authority of the legislatures to enact transitional provisions to effectuate mandates that are in an act that apply to varying degrees local governments that have different timing and different schedules with regard to elections. And I point in both Leach versus Wayne County and the Maynard versus Leach cases, those were ones where they were using transitional provisions that did affect the timing of elections and the shortening of election terms. And the Supreme Court upheld those as part of transitional provisions that were enacted as part of a general law that was effectuating a change in structure of local governments, or how certain officers were elected or selected in local governments. So, and once again, we take the position that the holdings in those two cases are not limited solely to legislative enactments that are intended to bring to fruition a constitutional change, but would apply to any kind of legislative action that's within their legal authority to alter or change or amend structure or form of local governments. So in light of that scenario, Your Honor, we don't think that the act violates Article 7, Section 1 in any way. And then the last argument that they have on the merits is count 4, where they talk about that also relates to Article 7, Section 1, that discusses the concept of the provision in there that says that there's a 25-member cap for county government bodies, but that metro governments are exempted from that and that shall not apply to them. And our position on that is, Your Honor, we don't disagree that that there is no constitutional cap for metro governments. That, however, does not mean that within the broad power of the General Assembly that they don't have the legal authority, constitutional authority to enact caps legislatively. And we think there's nothing in the Constitution that prohibits the General Assembly from doing that. And there's some comments about the Constitutional Convention and the delegates that were contemplating this exemption that Metro points to. But clearly, if you look, there's nothing in those delegate comments or history that shows that they wanted to prevent the General Assembly from enacting caps if it felt that it needed to do that or actually did that. So this concept of the cap and the use of that constitutional provision doesn't in any way mean that the General Assembly may not enact its own cap legislatively. So we don't think that the exemption provision of Article 7, Section 1 of the Tennessee Constitution in any way affects the ability of the legislature to enact the present act. So that addresses those issues. One other question that I was going to address as part of the merits argument is Metro's discussion about whether Section 1B of this act is severable. And while we submit that the entire act is constitutional and should be enforced, the issue arises, well, what if 1A is affirmed, but 1B is not and is declared to be unconstitutional for any of these various, pursuant to any of these arguments raised by the plaintiffs? And our argument with regard to that is if the court were to find that 1B was somehow violative of the Tennessee Constitution, that would not in any way prevent the rest of the statute, including 1A, from remaining in effect. Metro argues that the legislature would have never enacted the act if they couldn't put 1B in there. Well, that's pure speculation. The fact is, if you look at the act itself, it has a severability clause. Also, we cite in the brief the general severability clause in Tennessee Code that supports the concept of if the remaining portions of a statute can stand on its own feet after striking down a portion of it, then the remainder of that statute should stay in place and should be viewed as being effective and binding. And in this situation, Your Honor, we believe that 1A establishes the cap for all municipalities, so for metro governments, and that would remain in place regardless of whatever the court did with regard to 1B. And obviously we have Part 2, Section 2 of the act applying to municipalities, which I don't think Metro is challenging at this time. So we think the severability question raised by Metro has no merit, them opposing it, and it would definitely be severable if 1B was invalidated, which we don't think it should be. With regard to, I'd like to go into the other prongs of this analysis under Rule 6504. And I wanted to discuss the Metro Nashville's arguments about irreparable harm and injury in the absence of a temporary injunction. And one thing I would like to point out here with regard to this is that even though Metro is arguing that there's utter chaos and confusion and that there's no way they can achieve this in a normal, logical fashion, the fact is, from the record, they've been making progress in getting this redistricting process moving along. They recently didn't take any action on it for several days, and I assume they're having a hearing later tonight. But they clearly have taken steps forward and in an attempt to redistrict pursuant to the act. And we believe that with regard to that, if they take appropriate action and there's sufficient public education and disclosure about what's going on, that they could implement this for purposes of the August 2023 election and stay in compliance with the act to where the one-year extension wouldn't even come into play. So the concept of irreparable harm, all of their arguments are premised on the fact that the statute's unconstitutional. Well, remember, this is presumptively constitutional statute. So the analysis of whether it is constitutional or not, clearly from the perspective of the state, we believe it is constitutional, and any acts or injunctions that would infringe or prevent the act from becoming effective would in fact disrupt the orderly transition of this act and the implementation of deadlines established by it. So with regard to irreparable harm, we also pointed out with regard to that issue that even if the statute were declared unconstitutional or parts of it, if in fact they were in between elections or they were waiting for this August 2024 election time to come and the statute was declared unconstitutional, they could pursue a special election that would put them back under their 40 council member district and move forward with that. We, however, think that the statute is constitutional, and therefore the more vigorous actions taken to ensure compliance is the best situation to have to make sure that we don't have any inconsistencies with the enforcement of the statute. And one scenario I'd like to mention to the court is this concept of the harm to the state and the public interest. Clearly, as we've cited in the brief, the state has an interest in making sure that its laws are enforced and are not enjoined from being enforced. And in essence, because of the unique situation of Section 1A and 1B, I think it's clear that any injunctive relief that's issued that somehow stops 1B from going into effect, basically the legal effect of that is the issuance of an injunction to stop that would effectively nullify those provisions. And regardless of what the outcome is on the constitutional challenge, because of the time window we're discussing, if the court enjoined and said, well, you're not required to abide by the statute, including these short-term deadlines and the one, in essence, Metro would not be required to do that. The deadlines would pass, and this interim provision would basically be nullified, even if the court were found in favor of the state later on the merits of the constitutional claim. So it's a form of nullification by injunction, which we believe should not be done, and that the injunction should be denied for all the reasons we've stated, including the fact of what the effect of an injunction would be in light of the deadlines posed in the statute with regard to the election status for Metro. I'll see how much time I have, Your Honor. Let me see here. The other thing I was going to mention, Your Honor, with regard to that is the concept of irreparable harm and injury. And we've pointed out that if the state has its legislative enactments enjoined and cannot enforce those, that is a form of legal harm that is recognized by the courts. And we cited some cases in our brief that discuss that. And in light of the consequences that could arise if an injunction was granted, where in essence it's going to effectively nullify parts of 1B, if not all of 1B, depending on when the final determination on the constitutional claims come up, should be avoided in this case. The other, I guess the last point I was going to bring up, Your Honor, deals with the Moore versus Lee case that we were discussing, that Metro was discussing. And we just don't see, while we understand their interest in trying to argue that statute or that rule, that Supreme Court case somehow has application here. I mean, clearly the Purcell rule that's addressed in that is really one touting judicial restraint when it comes to requests for injunctions. I mean, what we have in this situation is Metro wanting an injunction to prevent a statute from going into effect, which is really not what the Purcell case and Moore versus Lee deal with. And we have, the constitutional issues at play in this case are different. It's not a voting rights case. It's not an issue there. It's whether the legislature has this authority to cap council members, the number of council members for metro government and municipalities. So it's not really deals with that concept. It's more, does the legislature have this authority, legal authority to do this? And if it does, then our position is that it should be allowed to take effect and should be moving forward, and that the court should not enter an injunction that would interfere with that lawful process. And have concluded my remarks, asking if the court has any questions. I was going to turn it over to Mr. Shirley on the standing issue if the court has no questions.
Chancellor Bryant, do you have any questions?
Not at this time.
All right, thank you. Judge Wagner, do you have any questions?
Sorry, I'm having trouble with my mute button. Not at this time. Thank you.
All right, very good. I don't have any questions for you, Mr. Simons. Thank you.
Thank you so much.
All right, and you are turning it over to your colleague, Mr. Hurley, for your remaining time.
Yes, Mr. Jonathan Shirley. Yes, Your Honor.
Shirley, I'm sorry.
Yes.
Thank you.
Thank you, Your Honors. Good morning, and may it please the court. I'm Jonathan Shirley with the Tennessee Attorney General's Office, and my comments will be fairly brief and will address the issue of standing, both as it relates to the ability of the individual plaintiffs to bring any of the alleged constitutional claims, and as it relates to Metro Nashville's ability to bring the claim that the act violates the 4-year term provision in Article 7. I'll start with the standing of the individual plaintiffs who are all suing either in their capacity as Metro Nashville voters, candidates for Metro Council, or incumbent council members on the Metro Council. Each of these plaintiffs lacks standing to bring all of the constitutional claims at issue in this case. To establish standing, a plaintiff must show 3 indispensable elements. First, a plaintiff must show a distinct and palpable injury. This cannot be conjectural or hypothetical. The second element is there must be a causal connection between the claimed injury and the challenged conduct. And finally, the injury must be capable of being redressed by a favorable decision of the court. The crux of the issue in this case relates to the first element, whether or not the plaintiffs have alleged a distinct and palpable injury. And I'll first address the standing of the individual plaintiffs in their capacity as voters. So in this context, the plaintiffs have alleged that the act creates chaos, confusion, and distrust from voters. Specifically, the plaintiffs assert that voters may have to get new registration cards. They may be voting in different districts than they're voting in today. However, each of these alleged injuries to voters are conjectural in nature, and more importantly, they're issues common to all Metro Nashville voters, not just the voters that are plaintiffs in this case. It's well settled that standing may not be predicated upon an injury to an interest that the plaintiff shares in common with all other citizens. And that's from the Darnell case. And while courts have found voter standing where a voter's right to vote is infringed, in general, standing cannot be predicated only on a plaintiff's status as a voter. An individual voter must show that he personally has sustained or is in immediate danger of sustaining some direct injury, and not that he suffers in some indefinite way in common with people generally, and must show that the statute at issue will impose burdens on him not common to the body of the citizens. and the plaintiffs cannot do that here. In ACLU versus Darnell, the court agreed with the state defendants that individual voters did not have standing to challenge a constitutional amendment. In Darnell, the voters' right to vote was not at issue. Rather, their alleged injuries resulted from their status as voters. In contrast, in the city of Memphis v. Hargett, the court held that Memphis voters had standing because their alleged injuries were premised on the right to vote. In Hargett, the court found that a voter ID law unlawfully burdened access to in-person ballots, added a voting qualification not present in the Constitution, and violated the right to equal protection by imposing different requirements on in-person versus absentee voters. Each of these injuries was palpable and affected everyone's right to vote. Here, no injury to a Metro voter's right to vote has occurred. There's been no allegation that individual plaintiffs will be prevented from voting by the act, and any alleged injury, such as new registration cards, new polling places, are merely conjectural and apply to all the Nashville voting body as a whole. And with respect to the Article 7, Section 1, about the alleged voters' right to select the officers, and while it's true that that provision provides the way in which those officers listed are elected by voters, the actual term is something that is the interest in the term rather is held by the person holding that office. And I think that is supported by the Marion Board of Commissioners case that's cited in our original our response to the original motion for injunction by Metro Nashville. I'll just read the quote from that case. It's talking about a different part of that section, but it also relates to the term. They say the constitutional safeguard providing that no office holder's current term shall be diminished by ratification of a constitutional article relating to elections was personal to the office holder and protected his term, not the office. Thus, the office of county judge terminated with resignation of the incumbent. So we would submit that the right to vote has not been infringed here. Additionally, while it's possible that the pool of candidates may change and districts may change, these injuries are not particular to any one of the individual plaintiffs and are instead a generalized grievance shared by a large class of citizens, the voters of Metro Nashville. Ultimately, the Metro Nashville voters will be able to vote and they will be represented by council members. In sum, nothing has been alleged here by the individual plaintiffs that is not common to any particular voter in Metro Nashville. Likewise, none of the individual plaintiffs are injured by virtue of being a candidate for Metro Nashville Council, and status as a candidate does not confer a right to bring a suit. A litigant has standing to challenge the constitutionality of the statute only insofar as it adversely affects his own rights, and it's well established that candidates do not have a right to run for public office. And that's from the Sixth Circuit Molina case that we cited in the brief. In addition to not having a right to run for elected office, the fact that a candidate for office has already raised campaign contributions and is campaigning is irrelevant to the inquiry of whether the candidate has standing to challenge the act. Ultimately, that candidate does not have a right to the office. And to the extent a candidate no longer wishes to run for office in a redrawn district, or to the extent that a candidate is unsuccessful in running for office in a redrawn district, the law already provides in Title II a mechanism for how unexpended campaign funds may be distributed, and includes but is not limited to giving campaign funds back to the voters. In other words, the law contemplates that candidates may not use all of their campaign funds. In the Hamilton case that we cited in our brief, the plaintiff alleged an injury in part because he was denied the opportunity to run for a city council position. The court disagreed, holding that there was no evidence that the plaintiff was denied an opportunity to run. And in that opinion, the court relies heavily on the Monsieur v. Haslam case from the Eastern District, wherein a plaintiff who wanted to appear on a ballot as a candidate for a judge alleged violations of the First and 14th Amendments. The court, while recognizing that the plaintiff was indeed denied the opportunity to be on the ballot, found it difficult to find anything more than a generalized grievance shared by a large class of citizens, all of whom were denied the opportunity to be on the ballot. Here, with the implementation of the act and the required redistricting, candidates' potential constituencies for the upcoming August election will be decided by whether Metro Nashville ultimately adopts a district map by May 18th. If Metro adopts the map, then the candidates will be running for one of up to 20 seats. If the law is overturned, then candidates will be running for one of 40 seats. Under either scenario, there's no denial of the opportunity to run for office. But to the extent the ability to run is impinged, anyone desiring to run for a council seat would encounter the exact same obstacles that the individual plaintiffs have asserted here. So the issues with the getting a petition, signatures, all those kinds of things would affect all council members, not just the ones here. Additionally, in Looper v. Bowman, a successful candidate for county property assessor filed suit seeking declaratory and injunctive relief for alleged election irregularities, which he claimed deprived voters of their right to vote for him. The court found that the plaintiff lacked standing, holding the alleged injuries were abstract and common to all voters or candidates, and therefore lacked the factual specificity needed for the court to make a decision. The same reasoning applies here. All of the alleged injuries are common to all voters, all Nashville voters, and all potential candidates for Metro Council. Furthermore, the individual incumbent council members likewise lack standing to challenge the act. It's clear from Tennessee case law, including Darnell and Mayhew, that legislators do not have standing to challenge a statute where the statute does not impede legislative power. Here, the act does not impede the legislative power of incumbent council members. Instead, the act affects only current council members, and that incumbents could potentially have an extension of their 4-year term of 1 year, and that is only if Metro Nashville fails to implement the act's requirements in time for the upcoming August election. This is not an impediment to a council member's legislative power or the effectiveness of their vote, nor is it cutting short their term. And moreover, if an incumbent is unable or unwilling to fulfill the remainder of their term in office, Metro Nashville has a procedure in its charter for filling vacancies. Individual incumbents do not have a right to hold their current office after their current term has expired, as they are only candidates for a future term in office at that point. Therefore, the same reasoning applies to the incumbents as to why candidates for Metro Council do not have standing. Finally, Metro Nashville lacks standing to raise the claim that the act violates the 4-year term described in the Constitution. Metro Nashville cannot show a distinct and palpable injury under Article 7, Section 1, because Metro Nashville was not elected to any legislative term. The term is personal to the office holder, not the office, as established in the Marion Board of Commissioners case. As a general matter, a political subdivision may seek a declaratory judgment regarding the validity of a statute, but it must be asserting rights that are its own. It cannot merely assert the collective individual rights of others. In its argument concerning the 4-year term contemplated under Article 7, Metro Nashville is asserting the rights of and alleging injury to others, namely voters, incumbent council members, and council members yet to be elected. And as just discussed, we believe that none of those individuals have standing here. Metro Nashville contends, additionally, that it has standing to litigate a change to the fundamental terms of the services of council members, who are the means by which Metro Nashville exercises its powers. But it cites no source for the same. And importantly, Metro Nashville keeps going no matter who is in office. The ability of Metro Nashville as a local government to enter into contracts, to sell bonds, to do any of the other powers that it is authorized to do under the code is not affected by who is sitting in a particular council member seat. Nashville also asserts that it's injured because it may have to pay council members an extra year if their terms are extended. But Metro Nashville will be paying council members no matter what, even if new ones are elected this year. There's no allegation that more than one council member will hold the same office, thereby increasing Metro's salary burden. This Metro Nashville's argument on this point lacks merit. And so for these reasons, we ask that the court find the individual plaintiffs lack standing to challenge the act under all of the asserted constitutional provisions, and that Metro Nashville lacks standing to challenge the act under the 4-year term provision of Article 7, Section 1 of the Tennessee Constitution.
Thank you, Mr. Shirley. Any questions, Chancellor Bryant?
No.
Any questions, Judge Wagner?
No.
All right, Mr. Shirley, I do have one. I would like to make sure that I understand your position. If the extension of the 4-year term were to be ultimately found invalid or unconstitutional, but the Metro Council had taken acts, entered into contracts, executed bonds by council members whose terms were extended for a year. What is your position as to the validity of those actions taken by council members whose terms were unconstitutionally extended?
Thank you for the question, Your Honor. And I think the answer to that would be that right now the act is presumed constitutional, and until it is overturned, those individuals are properly in office.
And so you're saying that the presumption of constitutionality would protect any actions taken by those council members? Is that correct?
I would think so.
Is that
Yeah.
your position?
Mhm.
Okay. I think I understand. All right. Let me pull, do we need to take a break, or are we ready to proceed with rebuttal?
I'm ready to proceed. I don't want to speak for Mr. Tift
Individual plaintiffs are also ready to proceed, Your Honors. Thank you.
or Your Honors. If Your Honors need a break, we certainly will take a
Now,
break.
probably the most important person to ask that question is the court reporter. Are you okay to proceed?
I'm okay. Thank you, Your Honor. I appreciate
All
it.
right, very good. Then we will return to Metro government for your rebuttal. I think you have about 10 minutes or so. If I was trying to watch the clock, is that right?
We show 15, but I hope I don't need to use that much. So I hope there's not a
Well,
conflict.
Well, that's all right. You had reserved 15, but I think Mr. Dietz ran over just a tad. So go ahead.
Okay, great. I'm going to begin by addressing just a few of the points that Mr. Shirley made concerning standing, since those are sort of fresh on all of our minds. Mr. Shirley mentioned that the districts that will be the districts for purposes of the May 18th qualifying deadline really depends on Metro. It depends on whether Metro is, effectively willing to comply with these requirements. And this amounts to nothing more than sort of it's all Metro's fault if they don't comply with the act. And I think the important thing to remember here is that the sheer act of complying costs Metro an extraordinary amount of human and financial resources. So never mind that the map that they would be adopting would conflict with the exemption for metropolitan governments in Article 7, Section 1. Never mind that. Never mind the rock in a hard place that Metro was placed in to even have to go through this process. Never mind the legislative priorities that Metro has effectively have to put on hold to deal with this chaotic process. And never mind the coming legal challenge that we know we will face by adopting this unconstitutional map. Mr. Shirley also mentioned that if council members, if Metro doesn't complete the redistricting and council members are required to serve a 5th year, what if council members choose not to do that? Which I think is a very valid question. And his response to that is, well, Metro has the authority to fill that vacancy. Well, respectfully, I can't imagine people are going to be lining up to fill a vacancy for 1 year of what we contend is an unconstitutional council member term. And I think it's also unclear what district are they even serving? Are they serving the 2011 district? Are they serving a 2020 map? This is sheer chaos. And the fact that no one knows what districts are going to move toward the August 3rd election is precisely the problem. It's just too late. And then finally, this notion of Metro doesn't have to change the salary of council members. They are cutting the size of our council in half. They are requiring our council members to double the number of constituents that they serve. To suggest that those folks would not be entitled to more money for having to do that it's absurd. Metro Nashville is having to make extraordinarily important public policy decisions right now based on an unconstitutional law, and they have very little time to do that. I'd now like to shift gears to some of the likelihood of success arguments that were made by Mr. Simons during the state's argument. He asked a question that I found interesting enough that I wanted to follow up on it. He said, who is covered by this act? And I think that's a really great question that we need to unpack a little bit. First of all, I think it's important to point out who is not covered by this act. And I mean by any portion of this act, and that's county legislative bodies. Notably, the House sponsor from Sumner County elected not to set a cap below the 25 cap in the Constitution on county legislative bodies, despite the repeated insistence that any legislative body over 20 is inefficient and just not good government, that purported statewide requirement doesn't apply to county legislative bodies. Mr. Simons does argue, of course, that the act applies to all metropolitan governments and all municipalities. And that is true of the cap that we've been referring to. But I thought it was particularly telling when he was making his argument that when he started talking about Section 1B, when he started talking about those specific requirements that have been placed into this act, he only talked about Metro Nashville. The cap that everybody is talking about is only in Section A of this bill. It's in subsection A of Section 1 that applies to metro governments, and it's in subsection A of Section 2 that applies to municipalities. Mr. Simons knows, everybody knows, that these redistricting requirements only apply to Metro Nashville. It's the legislative history is replete with comments about that. I would also suggest to the court that it is consistent with the Act's language that this Act, the redistricting requirements, the ones that force this chaotic process, those were never intended to apply to anybody other than Metro Nashville. And that's clear in the Act's own language. If you take a look at Section 2, of course, we're not challenging that because it relates to cities. But it's very telling that there are no such requirements in Section 2. It says you've got to comply with this cap, but there's no requirement about how you do that. They don't say, go make your planning commission, do all this stuff in a month. Nothing to that effect. There are no specific requirements there. And the AG concedes that if the purpose of the Act were simply to impose a cap, Metro would have to comply with that cap even without 1B included. Then why is 1B included? It's included because it applies to Metro Nashville. And they wanted Metro Nashville to take these extreme measures. I also want to address the reference to Civil Service Merit Board versus Burson. Civil Service Merit Board versus Burson is distinguishable from our situation precisely because of Section 1B. I think this argument would make a lot of sense if they had stopped at Section A. If they had simply said, here's the cap, it applies to everybody, go forth and comply. But that's not what they did. They said, go forth and comply to the municipalities. But for Metro, we want you to take all these extraordinary steps, and we want you to do it right now. And that's why Burson doesn't apply. In Burson, they just set a rule and they let the civil service boards comply with it on their own. That's not what this Act does, and Burson does not apply. I want to also take a minute to address these transitional provisions because I think it is very important for the court to understand what the state is asking you to do. The state is asking you to hold that the legislature of the state of Tennessee can pass laws that conceitedly violate the Constitution, conceitedly violate the mandatory terms in the Constitution, but they should get to be able to do that just because they want to, not because it's necessary to effectuate a constitutional amendment, which is what the court has historically said transitional provisions are permitted for, but just because they want to. We get to violate the Constitution through our legislation, and we get to change the rules however we choose. And then once those provisions are complied with, then we'll get back on track. I think that was the phrase that Mr. Simon used. The track that he's talking about is the Constitution. The Tennessee legislature has no authority to ignore the Tennessee Constitution and pass laws that conflict with that Constitution just because it wants to. The claim that the council member term extension is not right because May 18th hasn't arrived yet should be rejected. May 18th is 44 days away. 44 days away. And right now, this week, the Metro Council is meeting. Actually, it's tonight. The Metro Council is meeting to try to figure out what to do with these requirements. To suggest that this act is not right merely because we don't know what the ultimate impact is going to be does not remove the fact that it impacts Metro Nashville the entire time. No one knows what their districts are going to be. Metro is taking steps to comply right now. And the Attorney General is asking you to wait until May 18th to make a decision. May 18th is the qualifying deadline for the districts that we don't know what they're going to look like. These decisions have to be made now. There is no extension built into that qualifying deadline in state law. We need to know what the districts are going to be now, and we need to know before May 18th. I understand why the state doesn't want to talk about Moore versus Lee. I understand why. In his argument, Mr. Simon said the state has an interest in enforcing its own laws. And I understand that. The state also, however, has an interest in protecting the integrity of elections. And the state should not be permitted to pick and choose when they get to effectuate that interest. That interest applies as equally today as it did a year ago when they were making the opposite argument in Moore versus Lee. As Mr. Tiff pointed out, the Supreme Court, our Supreme Court, has already held that reapportionment on this schedule causes harm to the public interest. This court could rule in favor of Metro Nashville and the plaintiffs in the Tucker lawsuit based solely on those grounds, completely consistently with what our Supreme Court has already said. The state is effectively asking you to determine that there is nothing to see here. They can pass unconstitutional laws because they're presumed valid, and we're just supposed to turn a blind eye, even when they concede that they conflict with the Constitution. It's fine. We're going to gradually comply with the Constitution through transitional provisions. That is not what the law requires. This case is about democracy, and we are asking this court to protect democracy and grant an injunction in favor of Metro Nashville.
Thank you. Ms. Beth, I have one question and then I'll pull the panel. Are you aware of any cases where a transitional provision has been applied in the context of a statute as opposed to the implementation of a statute as opposed to the implementation of a constitutional provision?
We are not aware of that, Your Honor. The only cases that we have identified that address this that really raise this particular rationale are those that related to constitutional amendments. In fact, many of these cases are about the Home Rule Amendment and effectuating the authorization that is in the Home Rule Amendment. And of course, we would note that the state also has not identified any such case. And then finally, I would just note that it doesn't make sense. It doesn't make sense that the legislature should be able to say, we want to do this, never mind the Constitution. We're going to call it transition. As long as it doesn't violate anybody's constitutional rights for very long, it'll be fine. And the law just doesn't support that from a public policy or from a legal perspective.
All right, thank you. Chancellor Bryant, do you have any other questions for Ms. Bussell? All right, Judge Wagner?
I do have a question, and I'm gonna try my best to articulate this clearly. In one of your requests for relief, I think it was the third one that you mentioned, that if we find section B to be possibly unconstitutional, to sever it out. And if we were to do that and issue the injunction only as to section B, would it not leave Nashville in the same situation that you're sort of in now, as your choice of to either rush and adopt new districts to have those elected in August of this year, or potentially elect an unconstitutional, or it's not unconstitutional, but illegal council that goes over the cap? What would Nashville's position be then?
Yes, yes, Your Honor, thank you for the question. So I want to, I guess, put a slightly different box around that third request for relief. What we're really asking for there is, yes, for section 1B, if the court were to conclude that the local legislation clause argument or the 4-year mandatory term argument were the only viable arguments that we have, then the court could still grant an injunction. But we would ask that that injunction not just be as to those requirements in section 1B, but also as to the requirement in that the law be effectuated before the next general election. Now that is also in section 1B. It just goes on to say, here's exactly how you do that. But we would be asking the court to do that. And here's why I don't think we do certainly still run the risk of operating under an unconstitutional map. But of course, at that point, the court at least has passed over that question. The difference, however, is we've got 4 years to sort of deal with that problem. And I think that makes it from an irreparable harm perspective, it certainly decreases the ultimate harm to Metro. Yes, we still may get sued. Yes, we'll have to deal with that. But I do think it at least eliminates all of the immediacy of the problem, because it gives us time to litigate those issues fully prior to the next general election, which would be 2027.
Thank you.
All right, thank you, Ms. Bessel. And we'll turn now to Mr. Tift for your rebuttal argument.
All right, thank you, Your Honors. First off, I'd like to make it very clear that everyone's aware of what a radical position the defendants are taking about standing on the 4-year term provision. Defendants are asking the court to functionally remove that provision from the Constitution because they are saying that no one, period, has standing to challenge the 4-year term requirement. The Metropolitan government doesn't. And in their original brief, there was some language suggesting maybe individuals do. But now, just before the court yesterday in their briefing and today, they said that neither voters nor candidates nor electeds have standing. Who else conceivably could in these kinds of cases? A DA can on behalf of the government, which would be the same as Metro Legal, or an individual can do a relator case on behalf of the government. So if the government and the people have no standing to challenge a 4-year term requirement, then it is unchallengeable. They're taking the courts out of the process and allowing the General Assembly to do whatever they want on the lengths of term, because no one can challenge what they do. 5 years might seem reasonable in this situation compared to, if that's the case, they could extend them to 8 years, 10 years, 12 years. They can do whatever they want on the term, despite express black letter law in the Constitution saying 4 years because no one has standing. I want to point out on that, a point I don't think anyone has made. If you're looking at the Constitution itself, it says that local legislatures shall serve 4-year terms. In Article 2, Section 3, it speaks to the Speaker of the House and notes that the Speaker of the House shall serve terms for 2 years or until a successor is elected or qualified. Now, we're required by the jurisprudence from our state Supreme Court to precisely construe our Constitution, and where some language is in one spot but not in the other, to determine that that means something. The framers of our Constitution could have said terms are 4 years or until a successor is appointed, and other case law has sometimes allowed that for a transitional extension. That's not the case here. The case here for local legislatures says shall serve 4-year terms. And elsewhere, it says some other officers shall serve a delineated number of years or until a successor is appointed. So that distinction is important as you're construing this. Finally, defendants stated just in oral arguments that plaintiffs don't allege they will be prevented from voting or have been prevented from voting. But that's not true. The individual plaintiffs do allege that this act will prevent them from voting. It will prevent them from voting in August if the election is pushed a year later. It will therefore prevent them from voting every 4 years on their council as they are required, or it will prevent them from voting to ratify acts of local effect under the local legislation clause. And I believe that's my 3 minutes. So we thank your honors for your time. Certainly available to answer questions.
All right. Do you have any additional questions, Chancellor Bryant?
I did have one question. Are you talking about the possible problem with the 5-year term, but are you also raising anything about the subsequent 3-year term?
Well, yes, Your Honor. Certainly, the subsequent 3-year term would also violate the 4-year term requirement. And while there, as I just discussed, there are cases from other states where language does allow for, X number of years or until a successor is replaced that have somehow times allowed extensions. I'm unaware of cases that have allowed for shortening of a clearly prescribed term. So certainly having 3-year terms after 5-year terms would be a clear violation of that provision of the Constitution, and therefore, again, of the electorate's ability to elect people that serve 4-year terms under that provision.
Thank you.
Thank you.
Judge Wagner, any questions for Mr. Tift?
I do not have any more questions.
All right. Thank you all very much for your participation and your briefing and your arguments. I think they were very helpful. At this juncture, the panel will take the motions under advisement to allow us to confer and issue a ruling in accordance with Tennessee Rule of Civil Procedures 65.04, and we will do so as soon as we are able to. And that will conclude our hearing for today. Thank you all again for your participation. And this matter is adjourned. Thank you.
Thank you, Your Honors.
Thank you.
Thank you.